Welcome. Thank you for the intro. Um, I'm privileged today to introduce our moderator for the International Trade Workshop, Rennie Alston. Rennie's a very impressive gentleman. He's a CEO of the American River Group of Companies, president of the American River Brokerage Services, as well as the founder, CEO, and president of the Alston Group. Rennie has over 30 years of experience working with the Bureau of Customs and Border Protection and partnering governing agencies. He's recognized as a regulatory trade compliance expert, an experienced customs broker, and a specialist in global supply security chain and financial risk management. He currently serves as the managing director of the Association of Trade Compliance Professionals. I know you want to get started, so without further ado, I'm going to turn the program over to Rennie, who's going to introduce our all-star panel. Thank you.
Thank you, George, and welcome to all of the global trade and logistics professionals that have taken time out of their day to join us for this virtual discussion and workshop that will include content and touch points on current events, necessary updates on various topics related to global sourcing, selling, shipping on an international platform. I am honored to serve as moderator for today's event. Throughout my 30+ years of professional expertise and experience, I've learned many things. Two of the things that I hold in high regard, firstly, is to never rely on your own skill sets and intellect as a sole source of information with the expectation that you will succeed at any task. The value of networking, information sharing, and willingness to receive information is a key and age-old answer to the question that I am often asked: how do you stay abreast of all the information that you share? Secondly, my father taught me a lesson at an early age. He said that if you're the smartest person in the room, then you're in the wrong room. It is that lesson that makes me honored to serve as moderator for today's event, because the panelists that are on this virtual platform are leaders in their respective fields, educators in their own right, and have a collective knowledge base that will define this moment as a moment and an event in time that will share value to their peers and industry colleagues and represent examples of key points which decisions will be used to be made, strategies formed and forecasted, presented with informed compliance. I salute each participant today and encourage you to focus on the content and allow the multitasking to take a break for the next 90 minutes. Each of you have received a virtual handout, as Dan has alluded to, that consists of speaker bios and presentation material that will represent evidence of true educational and practical professional value forward. Now, with privilege and pleasure, allow me to introduce our panelists. First, Andrew Danis. Andrew is a partner in the Washington, D.C. law firm of Grove, Jaskowitz, and Colbert. Over 3 decades of experience he holds representing shippers, carriers, NVOCCs, ocean freight forwarders, intermediaries, customs brokers, and other companies in commercial, regulatory, and litigation matters involving international trade and transport. He's a co-chair of the ALG network of law firms, a network of law firms with attorneys and law offices in Europe, Asia, Africa, South America, and the United States. He regularly publishes on international trade and transportation issues in industry publications and academic journals and law reviews. He is active in various professional organizations, including current division chair on the American Bar Association International Law Section Trade, International Organizations and Regulatory Practice Division, past co-chair of the ABA International Law Section, International Transportation, and International Contracts Committees, co-chair of the Transportation Lawyers Association, Antitrust and Unfair Trade Practices Committee, and recipient of the Distinguished Service Award for Transportation Lawyers Association. Next on our panel is Marianne Rowden. Marianne is the CEO and director of E-Merchants Trade Council Incorporated, EMTC. a new global trade association for e-commerce entrepreneurs that was created to support the simplification of trade, tax, and transportation. EMTC facilitates dialogue among e-merchants, worldwide community, and the global regulators. As CEO, she leverages her broad network of policymakers in the United States and at international institutions such as the World Trade Organization, World Customs Organization, the World Bank, UNCTAD, to present positions that support the growth of e-commerce across all participants in the supply chain. Ms. Rowden brings far-reaching experience in trade policy. She is recognized as representing her expansive network of unparalleled technical trade experts before congressional committees and their staff members, U.S. Customs and Border Protection, U.S. Census Bureau, the Consumer Product Safety Commission, the Bureau of Industry and Security, the FDA, U.S. Food and Drug Administration, and EPA, the Environmental Protection Agency, and as well as several other federal agencies. And lastly, allow me to introduce our third panelist, Jared. Jared Slaughter is the Senior Director of the Global Logistics for Keen Footwear. With over 20 years of professional service as a TLC board member and frequent conference panelist, Jared has over 25 years of experience in transportation and logistics management. Currently leading Center of Global Logistics Operations at Keen Footwear. Responsibility includes logistics and trade compliance. Fortune 500 experience in various roles of logistics management at Nike and Columbia Sportswear. Jared specializes in logistics procurement, negotiations, factory direct shipping, distribution, bypass, ocean transload, logistics contracting, logistics management, vendor compliance, TMS, international logistics, and origin of CFS operations. So again, join me in welcoming and allowing our panelists to present and display as we go through this very, very important workshop. I'll pass it over to Andrew.
Thanks, Rennie, and thanks to George and the Transportation and Logistics Council for inviting me to be back and present again. It's my pleasure. I always learn more from these webinars than I think I actually convey. So I'm going to be fairly quick in my comments, in particular because I only have 20 minutes to cover a lot of material. And I've decided not to share the slides that are in the handouts. I hope to cover most of the material in it. And if you do have the handouts ready, start at page 8, go on, follow, but we'll cover it. I was asked today to give kind of a 30,000 feet overview of the key players in international trade and logistics and some of the key roles that they play, and then also go a bit into contracting issues and legal issues that come out of the COVID supply chain process. And there's a couple of takeaways that I want to start at the beginning and giving you, which is the supply chain crisis is not over. You can see the charts. The Federal Reserve has a chart saying that, well, the disruptions are going down. Certainly the marketplace is saying, if you take a look at rates and capacity and what's happening in the market, the crisis is over. But in reality, we're just doing the onward effects. The underlying aspects of the crisis that were there are still there. They haven't been resolved yet. And in addition, there are a lot of tools and issues that going into the next contracting season, then a few years from now, going on down and looking and sourcing and supplying, you're going to have to take those lessons away. So what I would like to do at the start here is to give you the overview of who are the players, who are the rules, what are your options, and then follow through with, well, what happened in the 2020-2022 crisis, and what's the foundation that you're going to have to look at moving onwards. So the first thing to bear in mind is that when you're importing and exporting around the world, you have a number of players and you have a number of options as to how to either source goods or move goods. You have an importer exporter if you're a beneficial cargo owner, or if you're an agent of a company like that, or if you're a company that's engaged in wholesaling distribution. You may be a carrier. You could be a motor or rail carrier, international air carrier, an ocean carrier, 3PL, an international transportation intermediary. You may be a customs broker, or you could be an export freight forwarder. There's another player that's also involved in any international transaction. That's government authorities. Those are going to be customs authorities and other government agencies that regulate import or export transactions. As a practical matter, people talk a lot about, with the trade wars with China or with COVID and the supply chain disruption, that, well, we need to nearshore, we need to reshore, we need to make changes as to how we source goods internationally. Marianne and Jared can go into great detail on a lot of the practical aspects of that. From my aspect, wearing an attorney hat, nearshoring doesn't mean anything. Nearshoring, the only nearshoring that can occur is if you're going to locate your facilities in either Mexico or Canada, in which case a motor and rail carrier suddenly becomes important for you for cross-border trade transactions. TLC has great webinars and programs on cross-border transactions, so I'm not really going to discuss that. Any sort of nearshoring that's occurring that's either not relocating your facilities into the United States or putting them in Mexico or Canada means that you're going to either have to bring the goods into the States utilizing an air carrier or an ocean carrier. So let's take a look at those options. International air, that's an area that back during the supply chain crisis, we weren't hearing a lot about the service problems and some of the legal problems. You were hearing about cost and freight, and then maybe onward activities with, let's say, domestic drayage. But contracting with air carriers was very simple. And there's two types of air carriage you can contract with. One's a direct air carrier, which, or the other is an indirect air carrier, which is an intermediary. There's also an entity called an air freight forwarder, which can sometimes be an indirect air carrier or not be an indirect air carrier. They act as an agent. The key thing to remember about international air cargo contracting is that it's mostly deregulated. The services are going to be regulated for security purposes. Transportation Security Administration has key criteria. The FAA is going to regulate air carriers, and foreign entities that are offering services need to be registered with the FAA. And the other thing to bear in mind is that if you are dealing with an international carrier, whether for air purposes, whether or not they are an indirect air carrier or a direct air carrier, they are going to have an airway bill. And that's how you know you're dealing with a carrier. And that airway bill is going to have certain terms and conditions that are going to set forth your contractual terms. You can have a separate contract with an air carrier to bring goods in to the States or export them from the States, but that airway bill will probably have terms and conditions in them that match the Montreal Convention, which is a international treaty that sets forth standard liability terms for carriage of goods by air, both for passengers and for cargo liability. The key thing to know about that is it puts certain limitations on claims and when you can file them, the burden of proof, and the threshold bottom level that an air carrier can limit its liability. It's 22 standard drawing rights per kilogram, which I didn't do the conversion today, but it can range anywhere from $13 to $16 a pound as far as loss and damage is concerned. That's international air carriage, and that's one of your contracting options out there. As a practical matter, and what the bulk of our discussion today is going to be on, is international ocean shipping. And international ocean shipping is subject to a jurisdiction of the Federal Maritime Commission and a number of statutes that are variations of the Shipping Act of 1984. The most recent one is the Ocean Shipping Reform Act of 2022. And there's a couple of key things to keep in mind about ocean shipping because it's going to affect how you approach contracting and how you deal with carriers in bringing goods into the States or out of the States. The key thing to remember is that it's a regulated entity, and it is much more regulated as far as the rules and conditions are concerned than some other modes of transport, for example, motor carriage in particular. The second thing to bear in mind is that it's subject to an antitrust exemption. Ocean carriers are allowed to engage in alliances where they can share certain information and coordinate sailings and even coordinate some space allocations. And that's when we take a look at the contracting issues that occur in the marketplace. Some of the contracting issues arise because the carriers are able to go and try to coordinate capacity in the market and coordinate services. The quid pro quo for that is that both the contracting and the rates of ocean carriers and transportation intermediaries is subject to regulation and certain prohibitions under the law. The second thing to bear in mind is that those same prohibitions can apply to the activities of shippers and intermediaries that are operating in the market. And the third thing to remember is that all of the rules and regulations that apply for U.S. shipments apply only if the goods are transported through a U.S. port to a foreign port on a vessel. So by way of example, if you are importing goods from Shanghai through Des Moines, Iowa, if you move that shipment through the port of Oakland, and then it, let's say, goes by rail and then motor carrier, that's subject to regulation. The rules and regulations of the United States applies, and much of what I'm going to discuss apply on that. On the other hand, if it moves through the port of Vancouver, British Columbia, and then crosses the border, let's say at Pembina, North Dakota, that movement isn't regulated. And the reason for that is it's not through a U.S. port. So that's a key criteria to keep in mind. The players in international ocean shipping is the ocean common carrier, the non-vessel operating common carrier, an ocean freight forwarder, a shippers association, and a shipper. Shippers associations are buying groups. They're kind of like Costco. They're groups of importers and exporters that consolidate their freight to get volume discount rates. And they ship, they're treated mostly under the law as being similar to beneficial cargo owner shippers. With respect to transportation intermediaries, there's an entity called the Ocean Transportation Intermediary, or OTI, which confusingly is both an ocean freight forwarder or an NVOCC. So an ocean freight forwarder is a legal entity that is based in the United States, licensed and bonded by the U.S. Federal Maritime Commission, that provides export services. And the export services it will provide is booking cargo, preparing bills of lading, arranging for transport from origin to port, arranging for warehousing, arranging to file export documents if needed, providing advice on export licensing and other type of activities. There's a long list of regulated activities that the FMC looks at to say, well, you're an export ocean freight forwarder and you can provide these services. And it's kind of, I know it when I see it type of situation. The key thing is if they book cargo and help prepare a bill of lading, then they may be required to be licensed as an export ocean freight forwarder. The other thing to keep in mind is that they are not shippers under the law, so they can't enter into contracts, and they're not they're not carriers, they're not common carriers, so they can't enter into a contract of carriage with the customers. I'm going to discuss, though, they can enter into contracts. NVOCCs are legally common carriers. If they're based in the United States, they need to be licensed, publish a tariff, and have a filed bond with the Federal Maritime Commission. If they are based overseas, then they are required to be registered with the Federal Maritime Commission. They must publish a tariff, and they must be bonded. However, they do not need to be licensed. And again, the key difference there is that the U.S. can't exercise jurisdiction over the activities of an entity that is not performing services outside of the United States, it can exercise jurisdiction over an entity that is engaged in commerce with the United States. One other key thing to remember is that ocean freight forwarders, if they're based in the United States, they need to be licensed. The same legal entity that is performing the services for an import shipment to the U.S., if they're performing those services, let's say in Spain to New York City, that service, the exact same service, isn't regulated. Let's talk a little bit about ocean contracting. If you're following through on the slides, this is slide 11 of mine. Ocean carriage is subject to a regulated pricing scheme. And by that, the government doesn't actually regulate the prices, but the government regulates how the prices and the terms and conditions are entered into. And there's a couple of ways that can happen. One is if it's a common carrier service, an ocean carrier or an NVOCC, they are required to offer their terms and conditions and their rates in a published tariff. They self-publish the tariff. It's no longer required to be filed with the Federal Maritime Commission, but that tariff is basically the spot market rate that's out there. And that rate will apply to any shipper that meets the qualifications for it. And under the law, legally applies. You can't deviate from that rate. So it's unlawful to ship goods with an ocean carrier or an NVOCC and not have it in accordance to a published tariff rate. The exception being that ocean common carriers can enter into service contracts, which are contracts that have defined set of required terms and conditions, port pairs, geographic pairs, commodities, minimum quantity commitments or liquidated damages clauses, the line haul rate, and any other terms and conditions of service that may apply. Those contracts need to be filed with the Federal Maritime Commission. Then you have NVOCCs that can offer similar types of contracts called negotiated service arrangements or NVOCC negotiated rate arrangements. So an NRA, just to close the loop on this, is basically a exemption from a tariff publication. It's a quoted spot market rate that an NVO offers to its customer. And if the customer accepts it, then that applies rather than the tariff rate. A couple of key things to remember about ocean shipping. Cargo liability is limited. Under the Carriage of Goods by Sea Act, a common carrier, either an ocean carrier or an MBO, is required to issue a bill of lading upon request. They can limit their liability, but not below $500 per customary freight unit or package. And the limitation of liability can be extended both from point to point as opposed to port, and also extended to subcontractors under a provision in the bill of lading contract called the Himalaya Clause. And one other key aspect to remember and bear in mind is that frequently carriers put in their bills of lading dispute resolution clauses that govern forum selection and choice of law. And under U.S. law, it's legal to have claims disputed claims resolved, let's say by mandatory arbitration under foreign law in a foreign country. The example I give is a case that involved a shipment of oranges from Israel to Massachusetts that had to be arbitrated under Japanese law in Tokyo because it was a Japanese carrier. And the shipper didn't know it. So as I suspected, that took up lots of time. So I'm going to spend the last 5 minutes talking about competition in ocean shipping and the supply chain crisis and some lessons that we've learned. Everybody knows what happened with COVID. Everybody knows that prices went through the roof. There was a shortage of capacity in the market and that contracts weren't being honored. And there's been a lot of debate in the marketplace as to what happened due to COVID and why that happened. Was it simply market supply and demand situations? Was it price gouging in the marketplace? And in particular, how do we solve this and how do we solve this situation? In Europe, the solution has been that they've just announced, both in the EU and the UK, that they're going to revoke or not renew the antitrust exemption for ocean carriers. They're saying that it didn't lead to market efficiencies, and so carriers can no longer automatically enter into agreements that let them coordinate services. Doesn't mean that it's unlawful for them to coordinate services. They just need to be able to do it under the same laws that apply to any other legal entity under the antitrust laws. In the US, the solution was, well, let's go and enact the Ocean Shipping Reform Act of 2022. And that went into effect on June 16, 2022. There's a couple of key things to know about the statute. The first, and this is in the slide deck, so you can go through and look at the slide deck. It came up with new guidelines and new invoicing requirements for detention and demurrage charges. And carriers are required to adhere to those guidelines for invoicing purposes in order to collect detention and demurrage charges. It doesn't necessarily mean that detention and demurrage charges won't be collected. The Federal Maritime Commission has a regulation or a statement of policy that says, well, when the charges for detention and demurrage are reasonable or unreasonable, and it's based on an incentive principle. Congress has now enacted that into law, so the rule itself applies. How the rule applies, though, is slightly different, and I'm going to discuss that in a second because it's important for knowing your contracting rights down the road. The second thing that the statute did was it put in new prohibitions or asked the FMC to come up with new guidelines for unreasonable refusals to deal. And the FMC is still doing rulemaking on that. Again, there's some key developments that have occurred in the last 2 weeks that are very important to know. So for future contracting. So it remains to be seen what the FMC is going to say, but we're starting to learn some lessons from the supply chain crisis that frankly are really important for contracting purposes. There was some strengthening of common carrier prohibitions, and the Act also, OSHA 22 also came up with new charge procedures at the FMC, and then went and came up with new data requirements. And data requirements and data flow issues are actually important in the law. And Rennie, I'm going to run about 3 minutes over, I think. But what happens as part of OSHA 2022 was a recognition that there's not a lot of communication that's efficient communication between all the players in the transport logistics segment when it comes to international in particular. Ports, carriers, shippers, draymen, all are working on their own data systems, and communication becomes a major issue. Detention and demurrage, for example, the question on that is well, were some of the charges that incurred, are those charges being incurred because there was lack of capacity or lack of availability of dray carriers, or was there lack of communication as to when the port slots were open? And so the gates were open for return of containers. And those are issues that are still being debated. But OSHA 2022 recognized that. So it did one thing, which is it went and it said, let's have the FMC study this and with the National Science Foundation and come up and see what type of criteria can be developed to go for data flows and data information. The second part of it, and one of the reasons why the supply chain crisis is not over, is because the US government's recognizing that there's actual national defense issues coming up with this lack of coordination. So the Biden administration came up with the White House Supply Chain Resiliency Council, which is a follow-through on the supply chain crisis task force that it had, and is building upon both the Infrastructure Act that was passed and the CHIPS Act that was passed to mandate that the federal government go and work both with the private sector and also with the various government agencies to ensure that there's data flow information and also that the states and the federal government are working in partnership to build infrastructure so that crucial infrastructure, in particular with a focus on the ports, isn't hampered in the case there's another supply chain crisis, or if there's a COVID epidemic or another pandemic, or in the case of war. And so we referenced there's a fact sheet that was passed out on the White House Supply Chain Resiliency Council that goes through all of the different agencies and what they're doing. The key one to bear in mind is flow, which is with the Department of Transportation. They've come up with two different items. One is a multimodal office to work with multimodal development issues. And then the other is the data flow, the flow data flow, which is working with major beneficial cargo owners, carriers, shippers, port authorities. There's a list of about 30 entities that are involved that are voluntarily engaged in data sharing. This last few days, they've actually put up a prototype API that's going to go and give projections as to data flows. Now, it's just a snapshot, but the idea is that you're going to get less supply chain disruption in the future if you have a better snapshot of where the market is. U.S. government's also working with a number of other countries, again, to give visibility to the supply chain. The one last item I'd like to discuss, and then I'm going to wrap this up because I am running over and I understand that, is practical legal contracting issues. And in question and answers, we can go through this. There were a lot of complaints during the supply chain crisis that ocean carriers weren't contracting and were imposing unreasonable charges or not adhering to their contracts. Bed Bath & Beyond is the case that's getting all the headlines. They went bankrupt. They're suing multiple ocean carriers, both in bankruptcy court and at the Federal Maritime Commission, claiming that they basically were forced into bankruptcy because their contracts weren't honored. The most recent complaint that was filed about 2 weeks ago is alleging about $36 million, I think, and seeking double reparations for what essentially was, we had a contract, you didn't carry our cargo, you required us to pay surcharges that we weren't required to pay under our contract, but you told us we wouldn't handle the freight unless we renegotiated the contract. And that's really the basis of their complaint. Now, they have other claims, but that's the basis of the complaint. That's also the basis of other complaints that have been filed at the Federal Maritime Commission. And the key thing on that to note is that we've suddenly started getting decisions coming out. And those decisions are not favorable to shippers. They are favorable to carriers. There was a decision a week ago by basically a furniture manufacturer, MSRF, versus HMM. And in that, they made basically the same allegations Bed Bath & Beyond made, that their contracts weren't being adhered to, that the carrier had agreed to certain rates and the carrier had agreed to certain service requirements, but the cargo wouldn't be carried unless higher rates were paid and the contract was amended. The initial decision in the case is basically thrown it out of court. Well, did throw it out of court, ruled in favor of the carrier. And what was found was, even though the Shipping Act has all of these rules and regulations governing unreasonable behaviors, it also says that the remedy for a breach of a service contract is a cause of action in court. And unless there's something more, the FMC is saying, no, a breach of contract is a breach of contract. Two key takeaways on this. And the first one is know what's in your contract. In the HMM case, there was a lot of cross-reference. The contract was sued upon because it had all of these guarantees. Here's the rate, here's the quantity, whatever. But the contract also cross-referenced all of the tariff provisions that the carrier had that said, we don't have to do this, we don't have to do that, we don't have to do anything else. Also had a provision saying that they were going to arbitrate the case in Dallas, Texas under Korean law. So, look at that. And what was found is that, look, you amended a contract 14 times, and each time you agreed to what they were asking. And the contract said there wasn't, the tariff provision said there's nothing in there that actually guarantees anything. So you haven't stated a cause of action. Same thing with a recent small claims case. Journal of Commerce referenced it yesterday about turn charges based on a service contract. Turn charges that were being charged by Hapag-Lloyd, I believe it was, for moving equipment under a uniform intermodal interchange agreement wasn't a violation of the Shipping Act, and it also wasn't a violation of the contract that the carrier, the shipper, and the trucker had. So my takeaway, and I'm going to stop here because I've gone over, is that you need to know in contracting, you need to know what's in the contract, all of the terms, and you also need to realize that your contract doesn't end when you sign the contract. Course of performance under a contract is as important, if not more important, than what happens or the terms and conditions in the contract. I'm going to leave it at that. I'm sorry I ran over.
No problem. Thank you, Andrew. I mean, as moderator, I will say that your examples on current events was very, very much appreciated, as well as the lay of the land over who the participants are in the global process. So I think as a logistics provider, there are many companies, again, who find value in the first part of your presentation because they're trying to figure out how can we expand our company footprint. And what role do we play? Is that as a freight forwarder, NVOCC, and just how to expand our footprint? And also for those who are trade members, who is, acting in a capacity right now, who is part and what roles do my business partners play in my current business process and profile? So again, thank you very much. We look forward to the cheese and crackers. Now, next, I want to introduce Marianne Rowden. Marianne, take it away.
Thank you, Rennie, and it's great to be back at TLC because when we did this presentation in April and all the presentations that I've done subsequent, I've had to update with on-the-fly changes that have happened this year, particularly with regard to e-commerce, but trade in general. So we're just in a very dynamic environment for this area. Okay, so sourcing, selling, and shipping, within the current trade environment is very volatile. So, I want you to spot issues here and have conversations with different people within your company to determine your company's risk. That is the big challenge here. Okay, so sourcing, we're going to talk about changes in U.S. trade environment, selling, shrinking the global market because of geopolitical issues, and then shipping. There is a drive for supply chain transparency. In your handouts, one of the documents that you have sort of at the end of the PADF is EMTC's e-seller checklist. And we designed that as a list of questions for e-sellers who don't know what they don't know. They don't know that they're regulated. And so instead of using terms importing, exporting, and transportation, we came up with the phrase sourcing, selling, and shipping. And so I was happy to lend it to this presentation. Okay, so this is basically our environment. The trade initiatives, and in fact, there was an article about this yesterday with regard to Taiwan, where Catherine Tai, I think with the Taiwanese trade minister, he wanted a deeper trade relationship. And she says, like a real free trade agreement with market access and lower duty rates. And she's like, that's not going to happen. So my understanding is that the Biden administration came into office not wanting to do traditional free trade agreements because they don't want to put them before Congress and have contentious votes. So we do have, I guess, free trade light with a Taiwan agreement and the Indo-Pacific economic framework. So one of the things that has happened is the United States has shifted from being the leader of free trade liberalization, to now, the first time, at least in my career, shifting to an industrial policy. And Andy mentioned the CHIPS and Science Act and also the Inflation Reduction Act, which is really, the Build Back Better plan light that puts major federal resources into green tech. Okay, so over the course of my career of 30 years, U.S. Trade Representative has been the primary U.S. official responsible for trade and trade negotiations and trade policy. That is totally shifted to the Secretary of Commerce, and it's a big change. Here we have the World Trade Organization was the last entity of the United Nations system. Prior to that, we had the General Agreements on Tariffs and Trade, but then in the Uruguay round during the Clinton administration, the World Trade Organization finally came into being. And we've been negotiating an e-commerce agreement for several years. This is the late breaking news that in 2019, and this has been longstanding policy, that we would have free flow of data. We would not require companies to house their data in country. We want the free flow of data again. We want to prevent countries from forcing companies to transfer tech. That's a big issue with China, obviously, and access to source code, which is obviously the main intellectual property crown jewels of most tech companies. And we want open competitive markets for digital goods and services. A bolt out of the blue was on October 25th. Was, I think, the latest negotiation round for the e-commerce agreement. And that was supposed to be done this year at the WTO Ministerial Conference 13. And the U.S. Trade Representative, not Catherine Tai, but the delegate to the WTO, announced that the United States was withdrawing its support for these 4 critical digital policies, because digital trade is sort of like the last piece of that agreement. And of course, those policies are generally opposed by authoritarian governments, obviously. And the reason was that the U.S. gave was that the U.S. wanted policy space to rethink regulation of digital trade. Now, it's not a coincidence that on October 30th, just a week later, the president issued Executive Order 14110 on the safe, secure, and trustworthy development and use of artificial intelligence. Now, this executive order is 36 pages. It is not a normal executive order commanding or directing a specific department or agency to take certain actions. It is a policy document, and it is very extensive, and I encourage you to take a look at it, because if your company's involved in technology in any way, you will be affected by that executive order. So the USTR's change of position means that there will be no global agreement on cross-border movement of physical and digital goods, which was supposed to be completed this year and presented to the WTO Ministerial in February of 2024. And for e-commerce, that means that data and digital trade will be subject to national laws and fragmenting the internet. So here, what I've done is try to put in buckets in the context of U.S. legislation where, the digital and the e-commerce stuff fall. And in 2023, we really have lost control of e-commerce, because traditionally the cross-border movement of physical goods would go through House Ways and Means and Senate Finance Committee for trade with foreign countries. But you have the direct tax side, where, you've got the American Rescue Act, and that's a 1099-K reporting issue for revenue or transactions over $600. Or I should say, they lowered the threshold of reporting down to $600. Digital services tax moratorium, OECD Pillar 2. So that's, again, a global agreement, but that has to be, put before the U.S. Senate as a treaty to be ratified. Biden administration hasn't even presented it. It's not on the list of treaties under the State Department that they've put before the Senate. So you have tax professionals actually implementing an agreement that is not binding U.S. law yet. We still are seeing holdovers, the sales tax from the Wayfair decision. And then you have the Small Business Jobs Act, which is trying to reverse that 1099-K issue and put it back up to the 20,000 threshold. Indirect tax, the big one is that WTO moratorium. It gets renewed every 2 years. So right now, cross-border goods, digital goods, you don't pay customs duties. You don't even file a declaration. Many countries do assess VAT on those transmissions. It can be anything from electricity to movie downloads. And that moratorium expires in March of 2024 unless it's renewed. So everybody's holding their breath now that the USTR has changed their position on digital, goods. What are we going to do? Will we see a scenario where that doesn't get renewed? The other one that's a new one is the Foreign Pollution Fee Act of 2023. This is Senator Cassidy of Louisiana, introducing a regime similar to the EU that would assess a fee on commodities that take enormous energy and emit greenhouse gases. So this would be a tax. So the EU version is called the CBAM, the Carbon Border Adjustment Mechanism. And our tax would be between 10 and 20%. And it's a whole list of goods. So if you're into commodities like cement, minerals, iron, steel, if you're importing those items, that tax would be assessed at the time of importation. Then you have the de minimis issues, and those are two bills. One would block de minimis from China. The other would reset our de minimis to whatever the importing country is. Then you have trade compliance. The Manifest Modernization Act. Right now, we have public disclosure of ocean manifest data. And now Senator Cassidy, along with Senator Whitehouse, has introduced a bill that would make public all that manifest data. And that's a real problem because that's how competitors can use it. There's a whole laundry list of companies that are supporting it. And the only people supporting it are the NGOs who use it for Uyghur forced labor tracking purposes and companies that sell data. They get this data and sell it back to you. So we have a problem with this because this is regulatory data that you're required by law to submit. And now it's being used for other purposes. And then Andy briefly touched on nearshoring, and those are the bills that have been introduced, but really haven't moved. I just want to take you through the dashboard of the UFLPA. This is on CBP's website. So if you're in supply chain, you really got to get serious about this because Customs is under a lot of fire from Congress to really implement it and issue those with WROs. And remember, it's a rebuttable presumption on the company so that you have to prove that your product was not made with forced labor. So it is a very difficult law because your reputational risk as a company is paramount here beyond the regulatory compliance. So I just have some details there, but here is a slide that has the resources for you as a supply chain professional, transportation or trade professional, where you can go to get more information to assist you in your compliance program to ensure compliance with the UFLPA. Customs Modernization Act. This is another update, so I'm going to skip this. So here we were negotiating the Customs Modernization Act, or 21st Century Customs Framework, with CBP. Senator Cassidy came up with a draft bill that he circulated in, I think it was November 2021. And I showed you, what the discussion draft was, CBP challenge areas, that's the phrase that they're using. with the Customs Operations Advisory Committee, their response to customs challenge areas. And EMTC and the Express Association of America actually put out a red line of Title VI and Title 19 of what we want in the law, how to integrate e-commerce into the current existing Title 19 for customs duties. Okay, so here's my on-the-fly update. On December 8th, Senators Cassidy and Whitehouse introduced the Customs Modernization Act of 2023, which appears to be more restrictive than the current statute and provides CBP with more enforcement authority, especially against, e-commerce. They're gonna have a regime where they approve whether you can use de minimis. Okay, and it also incorporates the disclosure of manifest data. That was a separate bill. They also incorporate that into this new bill. So that just dropped the other day, and I'm still looking through and doing the red line. So if you have more questions about that, let me know. Talking about de minimis, there's been an actual change in the structure of importers. It used to be the top 1,000 companies, importers and exporters, engaged in, had the 70% of trade by value and volume. And we had about 300,000 importers of record that imported more than one shipment. Today, and this is based on an interview I did with Anne-Marie Highsmith last year, that 70% of top 1,000 importers, their share of trade has gone down to 58.5%. 90% of the shipments entering the U.S. are de minimis. So it's a total change in the structure of how trade, at least on the import side, is happening. This slide is really interesting because it shows the before and after effect of COVID on e-commerce, because the e-commerce supply chain was the only thing that withstood the pandemic. And I think nobody predicted something like a pandemic having such a dramatic impact. But we are getting back to pre-pandemic levels. I'm not going to go into this quick. It's just the key rulings and pending bill in terms of blocking de minimis for China shipments. So take a look at that. Here's another grid, just in passing, that you should be aware of if your company is involved in technology or e-commerce in any way. Legislation regulating marketplaces fall into three buckets: antitrust, disclosure, and the only one that's really been enacted is the Informed Consumers Act, and then intellectual property rights. Okay, so those are the three buckets, and this is where we've lost control of e-commerce because different congressional committees are regulating different aspects of e-commerce, principally through the marketplaces. And it's having a dramatic effect, and it's going to get, I think, pretty bad over the next couple of years, where what we're used to in terms of regulatory compliance through customs or other agencies is going to be more difficult. So Federal Trade Commission, for example, is going to become a bigger player. So in S1421, the Cool Online Act, it would require disclosure of the country of origin of a e-commerce product posted on the marketplace when you sell it. Fine, no problem. The problem is that it has the Federal Trade Commission enforcing CBP's country of origin requirements. Now, Federal Trade Commission traditionally has had jurisdiction over the Made in U.S.A. standard, but that's not the same as the country of origin for customs purposes. So this is a real problem. The other dynamic that's kind of interesting, again, going to Andy's point about nearshoring with Canada and Mexico, obviously for several years, China was the #1 trading partner. They're down to number 3. behind Canada and Mexico. And I will tell you the call that I get the most is from private equity firms asking whether de minimis will go away, because they're looking at investing in warehouses or logistics companies in Canada or Mexico to fulfill the e-commerce orders in the United States. So it's a real hot issue right now. This is something that's kind of interesting. There is the something called the digitalpolicyalert.org that is funded by the Foundation of St. Gallen. And I highly recommend that you subscribe to it and you get it in your email, and they compile nice reports, but they also do great graphics. And if you go on their website, you can put in filters, and I think they follow like 20 policy areas that are trade related. Here we've got import and export border measures, and you can see the ones that are blue show that are the new pending. So this kind of shows to me how deglobalization looks when you have countries imposing all the new import and export measures. So I think this is where our future lies. Okay, so I just want to touch on, we talked about a little bit on the import side, the sourcing side. If we go to the sales side, you know, a big export market obviously is the European Union. Now, the European Union has a new customs reform package. And one of the things that they have done is they're getting rid of their de minimis. Now, they already got rid of their de minimis for VAT. So that happened a couple of years ago. But they're going to end their 150 euro de minimis for customs duties. So our U.S. exporters who sell e-commerce via e-commerce into Europe are going to have a problem, you know, because e-commerce has low margin. All right. So these are all going to raise the costs of doing business. Here we have another, you know, set of buckets. More export controls because of the geopolitical situation that was really started because of Russia's invasion of Ukraine. Again, sanctions. And then U.S. foreign direct investment policy. They're going to start restricting where companies can invest. I'm not going to go over this, but just realize it's there, 1321 de minimis on manifest. But then you have type 86 entry if you have PGAs or OGAs, and that's an actual entry type. So take a look at that. So I want to wrap up here with this slide, which is kind of interesting. Going back to one of the things that Andy talked about is the entities in the supply chain. And what I've compared here is who's in the traditional trade supply chain and the e-commerce supply chain. You have many more intermediaries, okay? So in particular, if you're using fulfillment services by Amazon, and Amazon is one of the biggest NVOCCs now. So be aware of that. On the carrier side, what's different about the supply chain is the Postal Service is a much bigger player, so they handle most of those e-commerce packages. And the final thing that I want to make you aware of on the fly is that the Federal Trade Commission has put out a an NPRM, proposed rulemaking. And I got to admit, I missed this at first because it was looking for hidden fees, you know, from a consumer protection point of view. They cited hotel industry and car rental, and I kind of looked at it and I didn't think anything of it. I was on a call with some e-sellers that are not within our association, and the Federal Trade Commission actually contacted them to get them to weigh in on this. And all these e-sellers want to go after the logistics and transportation fees. And I tried to say to these e-sellers, Okay, the Federal Trade Commission may try to do that, but transportation is regulated by other agencies. So I think e-sellers are going to have a rude awakening into, they're happy with the Federal Trade Commission going after entities on antitrust, whether it be the marketplaces or logistics companies. So we will probably file comments, advising the Federal Trade Commission. You probably can't do what you want to do in this space because it's so highly regulated by other entities. And so with that, I will hand it back to Rennie.
Thank you very much, Marianne. I mean, a wealth of information transfer, and again, meeting and exceeding my expectations on your presentation. Obviously, when individuals in the industry think about global trade and international, there are a host of topics to consider, right? When you're talking about current event points, other than just harmonized classification, valuation, and record keeping. So thank you for giving us a stroke of your genius on these touch points, and I look forward to the cheese and cracker session as well. Next, I want to bring to the forefront for everyone's value and information sharing, Jared Slaughter.
Thank you. You see it, Rennie? Excellent. Okay. Wow, I'm just this panel's been together before, but it just keeps getting better. I'm very impressed. And this could be, we could have named this session, Summit 24, as we prepare to turn the page on the calendar here. So again, thank you for George for having me as a longtime member of TLC and board member. Honored to have the opportunity to speak today. When Rennie was introducing me, I was like, who is that old guy that's going to speak later in the session? So I was like, wait, but that's me. So thanks, Rennie, for that introduction. And I'm going to get going here. Again, this is my kind of view. What George has always asked me to do on these panels is give a shipper's perspective. So that's what I'm going to do today. I do work for Keen. That's our amazing looking, very stylish sandal for everybody. And again, these comments today are mine, not representing Keen in how we do things, but really kind of our ethos of our our company and what I've learned over the years. So with that, the shipper's perspective, I'm going to use the experience that Rennie talked about in my 25 plus years. I'm going to talk about the importance of foundation. Really, when we look at this, I'm really a believer of plan the work to plan type of approach, because we must build resiliency in our supply chain. So I'm going to talk a little bit about that prior to getting to the topic of headwinds as looking forward to next year and what those, what are those key items on the radar. So first, I'm going to talk about, from a shipper's perspective, about center-led logistics. I get asked this from time to time is, how do you manage global logistics, at a company like Keen, where we have, Keen Europe, Keen Japan, Keen Shanghai, Keen Canada, and then Keen U.S. Well, we do this from a position of being center-led. What does that look like? Or why is that important? It's important because we must prepare for headwinds, right? And how we organize ourselves and how we manage and lead logistics. So there's three things that I want to talk about. One is scale. Sometimes shippers get this confused on scale, meaning they look at this as volume, leveraging volume for rates, right? Pound down carriers. That's not what I'm talking about. I'm talking about scale from a position to be able to prepare your brand and your company to be able to, at least do 2x the volume of what you're doing today, and how you view your logistics service providers. Can they provide service in potentially maybe it's Europe, but also can they scale in other regions where we can leverage their expertise and grow with us, right? We always want to look for those opportunities in our infrastructure. So when I'm thinking about infrastructure in the US, I also have to consider our other regions. That's what I mean by scale. And then process, we must, we have enough headwinds, right? As you saw the presentations earlier, lots of changes are in the roadmap for 24. Things are in flux. So to manage that, we must round ourselves with standardization of processes. And when we do this in center-led logistics, we're really defining standards, right? Building standards. I'm a Pittsburgh Steelers fan, so I'm going to do a Coach Tomlin. The standard is the standard. We reiterate that quite frequently at Keene. And we have great partners that help us do that. And that's what it takes. And then lastly is knowledge. What is knowledge? I would say in logistics that we must wear that badge of we are the logistics experts. We have to own that, right? And so how do we make sure that we understand value of our company, and how can we drive that knowledge, use that knowledge to drive awareness, decision making within our companies, and also, how can we be of value to everybody within the brand, right? We have internal stakeholders. So we have to own it, and we must own it. So what have we learned? Hopefully we just don't turn the page back 4 years in the past and say we didn't learn anything. Hopefully, as logistics professionals, there's some things to take for lessons learned, and how do we continue to improve? Okay, this is key, right? It's an evolution of logistics. First of all, in game, what is your brand trying to accomplish, or who you're representing? Where are you going? How are you setting your compass? That is a critical component when you're managing logistics and when you're leading teams, and even 3PLs. I think it's important that we share, especially as a shipper, to our logistics providers who are, a part of us, where we're trying to go, right? So that really feel like that's critical. And then you got to have a plan, right? I'm just kind of laugh a little bit, but we can't go by hope, right? We have to figure out is how are we, we know where we're going to go, and now how do we build a plan around this? So I'm kind of going through these items because the headwinds that are coming at us, these are foundational things that you must be doing now. We can't wait, right? And the next piece of this is building flexibility and resiliency within your supply chain. And that is really important that you think about that now, and you should be working on that, because your ability to be agile really is reliant on those two things. Okay, so let's say that you have a crisis today and you're thinking about the Panama Canal, but you don't have any resiliency. Your entire supply chain is very rigid. You're going to have a difficult time deploying levers to win. Okay, so this is day in and day out. We must stay on offense to build flexibility and resiliency within our supply chain. And then a huge one during COVID was making sure that we're driving awareness and communication and sound the alarm when needed. Okay, if as a shipper, if I went to the CFO at the time that I only stood there was understand there's a container that's going to cost me $20,000, I'm probably too late in that discussion, right? I need to drive awareness as a logistics expert within my internal influence, right? And also our carriers as well, all of our logistics providers, because we're in this together. So that's one key thing I continue to look at. You think about 24 the items I'm going to go into, make sure you have a good communication plan. And then lastly on this is relationships matter. You can be a transactional shipper. You can manage your providers internally as transactional. You're going to win in the short game. Why are we here? We're here to deliver our brand promise. We're here to deliver our product to our customers, which again we call our partners and fans. So to do that, you need to build relationships within your supply chain to help in the resiliency. Because if you try to be transactional and have headwinds, your conversations are going to be pretty difficult when working with your partners. Okay, so where does this lead me? Well, I was a young man at one point in my time. Back in 1997, I found myself being the traffic manager at a Nike distribution center. So I understand DC operations as product is king. I was frustrated one day. I was working on some projects and I thought, I'm working at Nike. Everything should just be, it happens and we're good to go and we're on to the next thing. Well, someone left a quote on my desk, and I think this is important, is The Stone Cutter by Jacob Riis. I'm going to read it real quick. When nothing seems to help, I go and look at a stone cutter, hammering away at his rock, perhaps 100 times without much as a crack showing it. Yet at the 101st blow, it will split in two. I know it was not the last blow that did it, but all those that had gone before. Pound that stone. What I mean is building resiliency, right? It's not going to happen overnight, but if you keep your focus on just what I just stated, you're going to be in a good position. The year of 23 was supposed to be return to normalcy, right? It was all supposed to be, back to normal, back to pre-COVID. We kept hearing that COVID was over. Okay. Going to give a plug here for Drury because Drury is an amazing service. If you are managing ocean, I highly recommend getting a subscription to Drury. The information is just awesome. But what I'm trying to show here just on this chart is the market for us for 23. I don't see any indicators on this screen that show green, right? Not saying that pre-COVID everything was green, but we had some green. We had a couple of yellows, but in the most part, we're not back into it in a state of normalcy, right? So, buyer beware. If you are getting tea leaves within your own company that everything is back to normal, you got to make sure that you're driving awareness because that's not the case. So, what does 24 look like? What are the major disruptors? And I could go on probably for an hour and a half, and Randy would have to, pull me out of the presentation here. But I was going to focus on three, but I feel for this webinar, I've decided to do 3 plus a bonus. So we're going to get a bonus round here in my presentation. So the first one here on the left is regulatory. So there is, I'm going to give an example of this that we got to be cautious of. Sustainability is important to the ethos of team. We're serious about it, and as the shipper, you got to do the right thing. One thing to be cautious of here is government or agency related regulation that is happening. I'm going to talk a little bit about the ETS, which is happening in Europe. Some of those on the call might think to themselves, well, Europe, why does that matter to me? Well, it's probably coming to America soon. Next is the black swan. COVID was a black swan. It really feels to me that climate changes, we're seeing more black swan events. And I'm going to talk about the Panama Canal. And really the tone there is building resiliency. Next is the ocean market. It's in a free-for-all for spot rates. We're close to pre-COVID rates. However, there's some impacts that are happening regarding the capacity level. Andy was talking earlier about some of the challenges during COVID. The carriers woke up, they heard our screams for more capacity, and they delivered, but it's going to be huge. And then lastly, my bonus one is, labor strife, and I'll get into that. And really, that note there is about diversification. So the ocean market, how crazy the world has it been? During COVID, Andy was talking about the contracts and carriers not fulfilling those contracts or what those normal rates were within those negotiations that typically happen in May, or I guess contract in May, through April of the following year. And it was a difficult time. Chart on the right just shows, it's a little bit dated, but it shows the spot rate changes over recent times and how they've kind of plateaued out somewhat, because they really, November of 22 is when the free for all started, of less demand and increasing capacity. So a couple quotes here on the left slide. If the spot rates go too low, carriers will do what they're going to do: blank sailings. Said a shipping executive in the JLC. Space is tight. It's on account of blank sailings, says John Moreau, NVO Advisory. And last, Sea Intelligence. It will take us 4 to 5 years to fill the ships. Massive overcapacity will stick with it. So, when we're educating those CFOs about, yeah, the spot rate's doing this, the rates are flattening out, yeah, that's an impact to the P&L. But if you're doing that, the next discussion, or maybe at the same time, you need to walk over to your sales team and your planning team, right, about there's disruptions that are going to be happening. Because why is the rates falling? Well, because remember what Andy was talking about the demand piece of it, about 2.5 years ago, as shippers and logistics professionals, we were saying, carriers have all this product that I need to move from my factories, in Asia or other locations, that I need to get on a vessel. I need space, right? And at some point in time, some shippers were paying $20,000, maybe $25,000. I think the most I ever heard was around $26,000 to $28,000 a container. Well, the carriers reacted. So they went, and what they refer to in this market is called the order book. So they did an order book, and it placed significant requests for bookings of increasing the vessels, right? So on this chart on the left, what you see is MSC on order, and this slide's a little bit dated here, but on order, they had 31% of the total fleet. That is incredible. We've never seen this type of growth. And now this space is coming into the market. So the carriers are trying to do their best to not have a free for all on rates going lower than they already are. So what are they doing? They're using their ability to, on these service streams, on their services that they deployed, what the market calls a blank sailings. Okay, think of it this way: you're at the airport and you got a ticket to get on the plane here. You showed up, 3 hours early. All of a sudden, the plane is canceled. Well, the plane is canceled sometimes because there's not enough passengers, right, for them to fly the plane. So they're going to do their best to control their costs, make sure they have high utilization rates on their vessels. And that's what we're seeing today. A lot of the ships are actually pretty full, but the carriers continue to blanks because they want to keep them full. They don't want lower rates to enter the market. So why is this important? Where's the so what in this, Jared? Why is this important to me? Well, it's because the blank sailings are disruptors in the supply chain. It's going to impact our lead times that have been improving over the last year. Our lead times are going to be challenged because all of a sudden we're expecting that ship to be there at port, and now it's not there, right? We did a really nice, we had Andy make us a really nice hosting contract with our carrier. We're going to hold them to the rate. However, we find out 10 days before that the ship's not going to be there because it got blanked. That's what's happening. We're also seeing that happen at tranships locations, which is a midpoint. Okay, ETS. I'll try to get through these quick, Rennie. ETS basically is a carbon tax that's been implemented. It is going to happen January 1st of 24. There's going to be considerable cost to importers and exporters. Why is this important? Because I understand that there's actually legislation today in the U.S. Congress that there is, aspects of trying to put something forth that's going to be similar. Am I saying that that's going to happen for sure? No, but likely at some point you're going to have to keep your eyes open, your ears open, and watch for this and continue to monitor. What else is happening here is, as shippers and logistics professionals, we must drive awareness, right, to our CFOs, our C-suite, that this is happening. We understand it. We also must budget for it. We're talking about 70 euros a container is what Merrick is going to put on their schedule, and each carrier is charging something different. Okay, and also that we understand this to be quarterly adjusted. So buyer beware. We do have some costs coming at us, and I'm sure I'm expecting it coming to the U.S. Oops. Okay, Black Swan. I talked a little bit about this, so I'll keep it short. Panama Canal has been experiencing severe drought. I understand now that there's several trade publications stating this is going to go through either late 24 or all the way through 24. So, the open logistics is not a good plan. We must be communicating that this is happening and the restrictions are in place. The big call out here is, at a point in time, container ships were getting priority. They had early reservation. They were moving through. So most of the articles that you may have heard was, oh, big backup. Well, initially it wasn't that big a deal for container ships overall. Now you can see in my highlight here on the slide is that the Panama Canal has put restrictions in for December down to 22 vessels a day, which is a 40% reduction over standard operations. And then in January, planning up to a 55% reduction. Okay, so you ask yourself, well, do I as a shipper have cargo moving through the Panama Canal? One, yeah, of course you should answer that. Secondly, if you're not, we know that everything's connected. This will be an increase of vessels flowing through the Suez Canal, right? Congestion is going to happen, and potentially there may be surcharges that are implemented at a later time, potentially. So something for it to be cautioned. And really the biggest one here is extended supply chain transit times. Okay, I would suggest that for all cargo moving through the Suez already, but especially if you're having to ship service strings to the Suez, you're going to see longer lead times. So you must, go talk to your planning friends, okay? Because you want to keep your salespeople happy. And then labor strife. So 23, can't believe this year that ILWU and PMA agreed to their 6-year deal that took over 12 months. We have the ILA on the East Coast and Gulf ports. Their contract, as I understand, is going to be expiring in October of next year. So caution. Maybe you don't use the West Coast, but we know everything's connected. So we will have both, sides of the U.S. impacted, and you need to build resiliency within your supply chain. And then last, just really just have a plan. We talked about that already, so I'm not going to go in depth because I'm going to hand it back over to Rennie. And there's my contact information in the slides.
Excellent, Jared. Again, I mirror what you said at the opening, that this panel, we've been together before, but this was an extraordinary presentation of information. At this time, I want to introduce Katie Warner, who has been an administrative assistant for TLC for over 13 years. She manages the membership as well as registrations and advertising for all educational activities. Katie?
I apologize. Here I come. Ready.
Sure.
Well, I want to say thank you all for attending today's virtual workshop, and thank you to all the panelists for your time to give this very informative presentation. For those of you who are not familiar with the Transportation and Logistics Council, our mission statement is education for transportation professionals. Today's virtual workshop is just one example of that. Please save the date for our 50th annual conference that will be March 18th through 20th in Charleston, South Carolina. We have a 2.5-day program with general sessions and workshops. Plus, we will also have 3 full-day seminars on March 17th on freight claims in plain English, contracting, and logistics in the law. Please visit our website at tlcouncil.org for more details. For those of you who are not members of the council, I would encourage you to join. Membership is for the company, so anyone within your company will receive member pricing on our seminars, virtual workshops, to our annual conference, and on our publications, plus many more benefits that are also listed on our website. As a thank you to our non-members for attending our workshop today, we're going to extend to you a special membership offer, so be on the lookout for that. And I hope to see you take advantage and join this wonderful organization. If you have any questions on any of our educational programs, membership, or just any general transportation questions, you can call me here at headquarters, or you can email me at diane@transportlaw.com. Diane and I job share, so we have one email. Thank you. Back to you, Rennie.
Thank you very much. So as we transition to our cheese and crackers discussion, we're going to open up the floor for questions to our presenters. And again, as part of the commitment to information transfer, I've always said that there are certain events that I hear were of value and wish I could have been a fly on the wall. So I appreciate the fact that all of you as participants were more than just a fly on the wall. You were participants in this information exchange. So I encourage you at this time, if you have any questions that you want to extend to the panel, whether it be to Andrew, Marianne, or Jared, feel free now to unmute yourselves and present your question. So I will generate some points that I have while we watch the questions populate. Andrew, first I'll start with you, and I invite the panelists to join in again in a response. But Andrew, you really hit home on something that I hold in high regard, and that is the importance of understanding, again, key players, and also understanding where contracts help protect the process, right? And I think something that was very, very prevalent in all 3 presentations was this aspect of connectivity. But I want to start first on the legal aspect. There are a lot of participants in the international supply chain who assume that the agreements that they have lived by, in past 2-3 years are enough moving forward, right? And knowing the terms of the contracts, knowing the agreements, not only that was the lay of the land prior, but due to where we are now in this return effort back to normalcy, the importance of communicating these possibilities to senior management. If you could just expand on how important it is to share with senior management these risks that must be protected in these contracts.
Absolutely. And Rennie, that's a great point. And one of the key takeaways is I represent both shippers and carriers and 3PLs. So I see it from all different sides on things. Mm-hmm. The key, the most important points of awareness that you need to have and that you need to take all the way up to the C-suite is you need to know who you're dealing with and what their actual hat is, what role they're playing. You need to know the transaction and how all of those parts work together. And then the third part is you need to know the contracts. And you need to understand where each component of the contract is working and whose contract you are actually dealing with. The biggest mistake that many shippers make, and frankly, even some 3PLs intermediaries, is they don't understand exactly how all the different pieces work together. And the fact that there may be all sorts of contract terms and conditions that are incorporated by reference or in the contract, or they haven't read it. I mentioned the reason I brought those cases up is because you can read all the hubris in it, all the concern in it, that, you know, what was happening in the market was outrageous. But then you have to put the legal hat on and you have to say, well, what actually happened and what did the contract say? And too frequently, in particular, when you enter into these transactions, people either look at the price or they look at the service and they don't take a look at what the deal is. And the carriers offering the deal are going to know. They're smart guys, smart gals. They know how they want to structure this. And so they'll go and they'll offer a boilerplate contract saying, this is what I'm going to give you. And someone says, I like the rates, I like the service. They never take a look at the terms and conditions, and they never take a look at how many other documents are involved.
Sure.
And all of that is absolutely commercially, that's fine. I mean, I understand that commercially until someone calls someone like me up. And there's nothing more frustrating in life than to have to call up an attorney and pay an attorney to give advice. And in particular, hear the attorney say, well, did you look at this? Did you look at this? Did you look at this? And so that's the type of information that if you want to take info to the C-suite as to what the risks are, you need to know the risks to begin with. And you need to know everybody who's involved and where those risks are. And it's just going to get even more complicated coming out of the supply chain crisis, and with the overcapacity and everything else. You need to know how all that's going to work together. And that's, as Jared said, come up, have the resiliency, have the plan, and know where everything is.
Excellent. Thank you very much. Marianne, I'd like to throw something your way. I mean, there was so much information embedded again in your presentation. I want to thank you. I had to pick and choose over what I wanted to ask a question about, but the compliance risk of sellers and buyers obviously takes on a whole new meaning to that legacy customs formality title that was introduced, you know, back when our friends at the International Trade Commission introduced Incoterms, right? And there are a lot of companies who are making decisions on whether they are, you know, in their sales or procurement practices, and looking at financial and compliance risk and what customs formalities are involved, right? But we're in a new day and age, and you really gave a great example where it's not the legacy players anymore. It's parties to the transaction, right? And it's specifically in the e-commerce field, you know, I run into companies who, even though they are a legacy player, their aspiration on business growth is to, again, prosper on the commerce platform. But it's not all roses. It's not an automatic fix, right? So if you had to, in a response, you know, address companies who are looking to expand their business profile in the e-commerce platform from traditional sales and traditional footprints, in addition to the points that you've given us before, if you could say, hey, what you need to look out for immediately when you're having these conversations and commitments to senior management on how lucrative e-commerce could be, in addition to be careful and be diligent.
That is such a great question, Rennie, really. And I'll give you two examples. So when I was practicing law after 9/11, international trade, well, prior to 9/11, most of our large importer clients in their contracts used FOB. I'm sorry, we had switched them over to FCA.
Right.
And after 9/11, because of the supply chain security requirements and CTPAT, we ended up switching them back to FOB because of where the regulatory intervention of customs was moved up. In the e-commerce context, the default has been DDP, delivered duty paid. Okay, so you're going to deliver everything. If you're an e-seller, you're going to deliver it to the customer with all the costs rolled in. Now, the reason those Incoterms, and I kind of thought maybe we should approach, EMTC should approach ICC with creating new Incoterms for e-commerce, because the supply chain is different. And I think that because you don't have that traditional importer of record, if you're an e-seller using DDP, you may be setting yourself up to being the default entity responsible for all regulatory compliance in the country of destination. Now, we know U.S. Customs, for example, and any customs administration, they don't have physical or legal jurisdiction over the e-seller outside of their jurisdiction. But, you know, it's very interesting because most countries have defaulted to what we call that intermediary model, where they're using the marketplaces to implement the regulatory compliance. And so I think this is all very much up in the air. And again, people are defaulting to that DDP Incoterms, and I think it may be a problem for them. So it's a great question, and it's something that I've been thinking a lot about. And we have to just see, particularly with the customs, you know, the new Customs Act, and, you know, there has to be some kind of synchronicity between, you know, what the law requires in regulatory compliance, but also the operational aspect and the logistics. And we're sort of out of sync. So that's why this is such a big problem.
That's great. I got one more question for you, Marianne, before I jump to Jared. You know, I noticed you mentioned the UFLPA information, and you had a great touch point in there that UFLPA is not just China.
That's
So
right.
it's very important. I just want to reiterate that point, that there are a lot of importers who are focusing on forced labor verifications and only focusing on China. But this is a very expansive effort. The U.S. government only started with China. The Xinjiang region is just the first focal point, but that,
Yes.
you know, that presumptive, you know, position again means that the burden of proof, as you laid out, is on the import of record. So, you know, excellent point. And I just wanted to reiterate that, you know, and thank you for that.
Yeah, and the only thing I would add to that is I used to have a chart, you know, where I would have a little icon for security, safety, you know, compliance. And the third one, which was a little cross on it, was humanitarian.
Right.
And that started out with the Lacey Act amendments and then the conflict minerals, and now obviously forced labor. But as you said, it started with the Xinjiang region in China, which I understand China is designated as a free trade zone area. But what's going to make this more complex, I think, is other countries are going to be roped in, you know, for their own, and the NGOs are on the, you know, the COAC work groups. They're on the operational level, and that's why they want this manifest data so they can really investigate it. But for logistics professionals and trade professionals, what's going to make it harder, I've been watching with some nervousness Chinese manufacturers investing in Mexico for logistics purposes, and then that launching pad into the United States. So I think I could see circumstance where the United States sends its attention to Mexico to trace where this stuff is made and try to unravel that thread back to, you know, China.
Yep.
So keep an eye on that.
Yep. Supply chain tracing. Very good. Jared, you know, appreciate all the comments as I noted in your closing. I wanted to touch and ask you to expand on the point you made, which was very valuable, on the importance of connectivity within the organization, right? And I remember way back over 39 years ago when I first started in this industry, someone told me that a successful supply chain is based on two deliverables: timely delivery and competitive pricing. Nowhere in there did they talk about compliance. Nowhere in there did they talk about all the other possible obstacles that could raise its ugly head. So on this appearance that we're moving back towards normalcy, if you could reiterate how important it is to keep those lines of connectivity open throughout the organization to make sure not only senior management, I'm glad you touched on sales, you touched on all the components within the organization, because it touches on procurement and sales, but the importance of connectivity to keep that transparency visible to everyone, and not just this blanket, hey, we're what appears to be normal, that we can relax.
Yeah, first I would say, in the last 3 years, working in logistics, it has had a lot of anxiety, right? It's been pretty stressful, right?
Right.
And so I really think as logistics professionals, you can't carry it yourself, right? You got to share the information. So one, make sure you're putting yourself in a position of success of sharing what's happening, right? You, as in a daily process, we must keep abreast of everything that's happening. It's difficult. You got to spend that 15 to 30 minutes each morning understanding what's happening, and then think about what the communication plan. I'll give you one example. So it's good question. One example of what I've implemented since I've been at Keene, and it became really apparent and important during the height of some of the challenges on the costing, is I said earlier in my presentation that we are logistics professionals and we have to own it. Okay. So that means that we do all the contracting that Andy's talking about, the ocean carriers. We do the RFP. But guess what? After we get those rates, we're not done. We have to build freight modeling. And after that, we have a cost per unit that's expected, right? We're still not done, Randy. What we must do and what we drive, my team, we schedule meetings with every single region within Keene on a monthly basis with their logistics department and their responsible finance department. And we go over what was the expected cost, what were the actual costs, what was the variance. We drive that. No one asked us to do that, right? And the finance like, oh, we probably don't need it that often, Jared. Like, we're facilitating the meeting. You're missing the point. We're inviting you to
Yep.
our party, and we're going to go over all this information because things are so volatile. You must continue to have that type of communication plan in place so you're driving awareness of what's happening and monitor it. So that's just one example I go
Yep.
through.
No, it's excellent.
That's really critical.
Yep.
And you
Excellent.
have to convey the messages that, Randy, is
Yep.
that, hey, this is a logistics meeting, but we are also responsible for all that contracting, and what
Sure.
Andy's talking about is
Yep.
we expected this price, we got this one, all that stuff, and drive that monthly communication with our finance teams.
Excellent. Thank you very much. At this time, let me introduce Brent Primus. Brent is an attorney with a practice that emphasizes on transportation and logistics. In the spring of 2020, Brent served as a director of virtual education for the Transportation and Logistics Council. He enjoys on the personal side, track side, to relax watching trains and to get a good feel for freight moving through the North American transportation system. So without any further ado, Brent.
Thank you, Rennie, and thank everyone for attending today. I want to thank the panelists. I just want to say that apart from the time of the presentation today, we had at least 3 meetings prior. So they invest a lot of their own time in this to make it a success. Before I say anything further, though, I noticed Amy Robinson, you had a electronic hand up. Did you want to have a comment or question?
I think I was only going to comment, Brent, thank you for giving me a moment, was just that there's a fintech tracing going on in regards to any kind of developments globally on investments from China into organizations that also happened after the Ukraine and Russia war started. And so this is being monitored really closely from the compliance perspective. And then I would just also add as a comment, I am soon to be the president of Women in Trade Compliance Northern California. And I commend this group for the work that they've done in putting this together and how incredibly professional and topical the information is and how you guys are working as a team. I know how much work goes into it, and I just applaud all your efforts and the extra hours in your day. So thank you for sharing all this really great information with us. Thanks, Brent.
Yeah, well, you're very welcome. Now just two housekeeping announcements. First, Rennie mentioned the cheese and crackers, bring your own cheese and crackers today, just for a little variation to get us in the holiday mood. Instead of cheese and crackers, if you can see this, we have some soft mozzarella and tomato slices, which I could hardly refrain from eating until the time to show. Second, by way of housekeeping, we have what we call our sponsor highlight. Our sponsors, we had them on the screen earlier. They're a key component of this. Today, the sponsor spotlight is on Pete Celestina. Pete, besides being a sponsor, he's one of our first sponsors for these workshops and virtually everyone. But even before we started the workshops back in the dark days of the pandemic in the spring and summer of 2020, Pete helped us, I conferred quite a bit with Pete about how to do all this. And he provided a lot of advice and support for us to try to go forward with this. 3 years later, things have changed, but we thank Pete for that. He was one of the co-founders of Trans Solutions, which became the claims management set of offerings within a company called MercuryGate. He's been around IT and logistics his entire life, began his career right out of college, started Trans Solutions, and one of their products is My Easy Claim. You might talk about here in a minute. With his two brothers back in '96. So he's been in logistics and technology for a very long time. Pete, would you like to say hi to the group?
Thank you very much, Brent. And again, we appreciate the work that PLC does educating the member base. As Remy mentioned earlier, I mean, what do you call it? We can't do this all ourselves. We're dependent upon everybody else to share information. And just like you guys share information, it's just important from my perspective to share our experiences with our customers and potential customers and others in this space. How we say, life is short, time is short. So whatever benefit we gain from others' experience and knowledge is, we're all good. We're all better off for it. But again, as Brent mentioned, that we've been part of Mercury for the last 4.5 years. I mean, we're in the software business. I know we have many members of the TLC that are our customers, and we continue to hope to gain additional members. But again, MercuryGate is a software vendor that plays in the TMS space, last mile space, freight claims, and then most recently we picked up a company called ITS, which is in the customer brokerage and freight forwarding, and they have a cloud-based application that helps their customers with that process in trade compliance and so forth. So again, Brent, I appreciate the opportunity to speak here. We will continue to support this into 2024. I know I've given Brent some additional. I know Chad provided a security update earlier this year, and I'm hoping that somebody from the IT side could provide some value to the members of the TLC. So again, folks, thanks very much. And again, you can see my background there. Holiday spirit. We wish everybody a very safe, Merry Christmas and a good New Year. Thank you very much, Brent.
Okay, Pete, again, we appreciate your support very much. And I want to mention that the registrants to today will all receive in a few days email with a offer that Pete's crew has put forward for a 90-day free trial to the My Easy Claims software program. Even though you on this program today might not be involved in claims, you may want to forward that on to someone who is involved in claims. So, Rennie, I'll pass it back to you.
Thank you. So In closing, I'd just like to again commend each and every participant, first on the panel, for your valuable contributions, and for all the members who have dialed in and joined in this virtual discussion. Again, I think we are all better off from the last 90 minutes plus on an information transfer. So again, happy holidays to everyone. Let's prepare for 2024, and we look forward to sharing information with you all in the future. Have a great afternoon.